Hey there, Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. I'm starting a series of videos on estate planning and probate matters. All these videos are for educational purposes. They do not establish an attorney-client relationship. My first video, I talked about being on an estate planning spectrum. So the second video, I want to focus on a simple will, because when you're thinking about an estate planning spectrum, even to start with good, we need to have a simple will in place. And I want to speak to the parents out there. Parents, you must think about protecting your children. You need to have a basic will in place so that in the event of your untimely death, you've got this document that will instruct everybody as to what you wanted and who should be in charge. Children want to know that their parents thought of them and protected them even in an untimely death. And I'm bringing this up because I was thinking about Anne Heche and the difficulties that her estate is going through. And it is so sad to see. And I understand there was some email she may have sent about what she would have wanted if she passed the next day, but apparently no, what you would consider to be will in place. And it's just such a shame. So think about taking action and don't wait. You can't just jump to the best estate planning when you haven't even started with the basics. Let's walk through a simple will a little bit, and you can think about how you would create your own will with an attorney, but have some of the ideas in place about what you need. So first, you want to have information about you, your correct legal name, your address, your next of kin or distributees. Here's where you really want to think, well, I'm married, not married. Was I previously married? If so, were there divorces, deaths? Do I have any children, biological or adopted? Have any children passed? If so, what are their dates of death? If they did pass, do they have any children? This essentially is information that I put in wills for my clients because it really shows that you knew the natural objects of your bounty when you were preparing this document, and shows the world who you presume to be your current distributees. Moving on from there, at least in my wills, I have a second article about deaths and funeral expenses. And moving on from there, I have my third article about tangible personal property. Tangible personal property should be carved out separate from the residuary estate for reasons I'm not going to get into now. But tangible personal property, think of the items that you can touch: the boat, the car, the furniture, the clothing, the jewelry, the books, all of that. So tangible personal property, you can say, to my spouse. However, if my spouse predeceases me, to my children in substantially equal shares. However, if any of my children are under the age of 25, for example, all tangible personal property to my trustee named herein to be managed and distributed according to the trust terms. Something like that. The next article would be the residuary estate, which is everything else. And again, we're walking through a simple will. So everything else then, let's say, for example, all the rest, residue, and remainder of my estate to my spouse. If my spouse predeceases me, to my children in equal shares. However, should any of my children be under the age of, for example, 25, then all of the rest, residue, and remainder of my estate to my trustee named herein to be managed according to these trust terms. And by the way, those trust terms can be very simple, especially when you're just thinking about laying the groundwork for some period of time before you can reassess and determine what else you may want to do. So in this example, moving past the residuary estate, we might have some other provisions in there, but of course we would have provisions in there in regard to executor appointments, trustee appointments, guardianship appointments if there are minor children. So it's not that difficult. You just really need to get started and have some basic information in place. You cannot jump from having nothing in place to all of a sudden having the best planning in place. And I always wonder, just for example, what happened in Anne's case? What was she waiting for? Why couldn't we, get at least the most basic things in place, even have the right executor appointed? So for you, what can you do to move you off of doing nothing to going to good for estate planning purposes? Please reach out with any questions, and please get moving on some things that you've been hesitant to take action on. Ruth P. George Law, PLLC, Trust and Estate Attorney, helping you with your estate planning and probate matters. See you on the next video.